Difference between tort and crime. Distinguish between tort and crime. Examination point of view. Introduction of tort and crime. Definitions of tort and crime. Distinguish between tort and crime. Before points to distinguish torts and crime, little bit write down about why it is distinguished. Points to distinguish both. Concurrence between crime and torts. Conclusion. Must be constructive. Crime. Introduction of crime. Crime is a social phenomenon. It arises first when a state is organized, people set up rules, the breaking of which is an act called crime. Actually, crime is considered against the society, and to control this, different punishments are implemented. Definitions of crime. Some definitions are: Black's Law Dictionary. A social harm that the law makes punishable, the breach of a legal duty treated as subject matter of a criminal proceeding. General definition. Crime is the violation of every moral rule established by religious usage or code of morality recognized by the people. Blackstone. Crime is an act committed or omitted in violation of public law forbidding or commanding it. Why there is distinguish between tort and crime. The distinction between tort and crime belongs to a comparatively mature stage of civilization. The laws of primitive communities were concerned mainly with the payment of pecuniary reparation to the person injured. Even for grave crimes like homicide and serious bodily injury, private compensation was allowed. Sir Henry Maine. The penal law of primitive communities was not the law of crime but the law of wrongs or torts. Anglo-Saxon laws were not very much advanced. They were mostly concerned with the recital of the customary amounts payable for various kinds of wrongs or injuries. WER was the price which was payable by the person causing death, and BOT was the payment for personal and other injuries. But they also contained the germ of the modern law of crime. In some cases a wite or fine was payable to the king or lord. It was only after the Norman conquest and during the reign of strong rulers like Henry II that courts were established which could punish all forms of violence as offences against the king's peace instead of allowing them to be compounded as private wrongs. At this stage, that the tort and crime which remained into hodgepodge for several centuries. The authors to draw a distinction between a crime and a tort remained with somewhat doubtful success. Holdsworth, the only certain lines of distinction are to be found in the nature of the remedy given, and the nature of the procedure to enforce the remedy. If the remedy given is compensation, damages, or a penalty enforced by a civil action, the wrong so redressed is a civil wrong. If the remedy given is punishment of the accused which is enforced by a prosecution at the suit of the Crown, the wrong so redressed is a crime. Distinguish between tort and crime. Following are the main distinctions between tort and crime. 1. Nature of wrong. Tort is a private wrong. Crime is an offense against whole society. 2. Remedies. Tort is a civil wrong for which the remedy is an action for unliquidated damages. A crime is a wrong for which the common law remedy is punishment. 3. Proceedings. Proceeding of tort can be brought in civil courts. Criminal proceeding can be brought in criminal courts. 4. Compromise. Tort being a private wrong, so an individual can compromise in suits with the defendant. In crime, compromise is only possible in cases of compoundable offences. 5. Pleading of case. Any private person can bring the proceedings. In criminal cases, government follows the case on behalf of the society. 6. Relevant law. The relevant law is given in Civil Procedure Code, CPC, is applicable. In criminal proceedings, CR.P.C. is applicable. 7. Intention. In tortious act, intention is not relevant. In criminal proceedings, intention is the gist of the crime. 8. Parties. In torts, parties are called plaintiff v. or s defendant. In criminal cases, the parties are called state v. or s accused. 9. Offense. Tort is an offense against one individual person, whereas crime is the violation of public rights and affect the whole society. 10. Subject of sanction. The sanction in tort takes effect only on the defendant's property. Criminal sanctions operate on his person as well, e.g. imprisonment. 11. As to defense. Necessity is a defense in tortious act. Necessity is not a defense in criminal act. 12. Codified law. Law of tort is not codified. Criminal law is codified and called Pakistan Penal Code (PPC). 13. Age limit. A person under 7 years is tortiously liable in tort. A person under 7 years is not criminally liable. 14. Limitation Act. In Law of Tort Limitation Act 1908 applies. 15. Evidence. The evidence is valued on the balance of probabilities. Prosecution has to priority the guilt of the accused beyond reasonable doubt. 16. Court's decision. In law of tort, the court speaks of findings or judgment. In criminal cases, decision of courts results in conviction or acquittal. 17. State. State only provides a machinery of justice. In criminal proceedings, state plays a vital role. 18. Unborn children's liability. Unborn child can sue after he is born in civil cases, but there is no legality of unborn child in crime. 19. Commencement of wrongs. Crime requires preparation while tort can be committed without it. 20. Attempt in wrongs. An attempt to commit a crime can itself be an offense, while attempt is not considerable to constitute tort. 21. Waiver. Criminal law does not allow waiver in case where privileged class has been exempted from liability, while in tort waiver can be used. 22. Element of wrongs. Mens rea requires to constitute the crime along with acts reus, while only action is sufficient to constitute tort, and ill will is no more necessary. One who trespass another's land or body must have to pay damages. Crime does not complete until or unless acts reus takes place. 23. Magnitude of wrong. Civil liability is measured by the magnitude of the wrong done, while in measuring the criminal liability, we take into consideration the motives, intention, character of the offender, and the magnitude of the offense. Concurrence between crime and torts. Same wrong, sometimes both civil and criminal. Capable of being made the subject of proceedings of both kinds. E.g. assault, libel, theft, and malicious injury. In some cases the civil and criminal remedies are not alternative but concurrent, each being independent of the other. The wronger may be punished criminally by imprisonment or otherwise, and also compelled in a civil action to make compensation or restitution to the injured person. Conclusion. To conclude, it can be stated that tort and crime differs from each other because tort is a private or civil wrong and crime is a public wrong. In tort, essential remedy is an action for damages, and in criminal law the object is always punishment. Tort is a crime against one individual person, whereas crime is against the whole society.